Before you appeal the examiner's decision, make sure you do these things. I'm Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and like, follow, and share. Okay, in my last video, I talked about appeals and why you sometimes need to file them. Before I go into an appeal, I like to do a couple of things, and I think it's good as a check on making sure you have the most fulsome case possible for the appeals board. So there's, I guess I would say, three things I basically do. The first is I go through the application and the claims, and I make sure that I have in the claims all the best subject matter that would, especially the dependent claims. I've really mined the specification for anything that I think might be allowable and have some value. You start out often with 20 claims because there's no extra fees for that. And so sometimes there's more stuff in there that you can wring out of the specification. And when I go into appeal, I like to have my best claims available for consideration because you're not going to get another shot after the appeal, basically. So that's the first thing I do. The second thing I do is I try to make sure I have considered what evidence might be available to me to support the client's case that's not yet in the record. What I'm talking about are usually declarations, either from the inventors or third-party experts, typically to rebut an obviousness rejection. And these declarations will typically be things directed to the secondary considerations of non-obviousness, which are things like evidence of unexpected benefits, commercial success, the invention solves a long felt but unsolved need. But, I'll try to go through with the client, what are the things we think demonstrate why this isn't obvious and why that's important, and can we get somebody with some credibility to sign a declaration and get that in the record before we go on appeal, so that will be before the appeals panel. But before I get to those two things, even, the thing I really try to do is to make sure that the dispute between me and the examiner is crystallized. And here's what I mean. In the patent world makes this distinction, which I personally think is not really a clear distinction, between the construction of the claims, that means what the claims mean or the claim terms mean, and then what the prior art says and teaches. And sometimes it's not clear if the dispute is over what the piece of prior art means or how a term in the claims is being interpreted. And clarifying that and sorting that out can help you really crystallize the dispute and make a much more persuasive appeal brief. When examiners write these office actions, they're under a lot of time pressure, and they're not models of clarity often. An office action doesn't look like a summary judgment brief that you'll see in a litigation matter. Things are conflated. They're done in a very summary fashion, and it can be difficult to really peel it apart and make sure where are we really disagreeing here. Are we disagreeing on what this piece of prior art teaches? Are we disagreeing on what this phrase in the prior art reference means? Or is this examiner interpreting the patent claims, my client's patent claims, in a way that's different than I am, and is it reasonable? Or can I deal with that interpretation by limiting the claims somehow? Now, often I try to push that issue in my initial office action responses, but sometimes it helps to have an interview and just have the examiner tell you, hey, what is it you think this is? What do you think this teaches? How are you interpreting this claim? Get something in the record to help crystallize the dispute, and hopefully in a way that will allow you to really demonstrate, the unreasonableness of the examiner's position in your particular situation. But those are the things I've found are important to do to strengthen your position on appeal, so you have the best chances for a good outcome. I hope that helps to keep you out of trouble, and I hope to see you here soon.